Hello everyone, welcome to LawPutra YouTube channel, and today we will discuss the topic attempt to murder under section 307 of IPC. Now before understanding the concept of attempt to murder, we have to understand what is attempt, and before understanding what is attempt we have to go through the various stages of crime. Now broadly there are four stages of crime. First is the formation of the intention, okay, which is also known as stage of intention. Second is the preparation to commit the offense or preparation or stage of preparation. Third is an attempt to commit the offense, which is known as the stage of attempt, and this is very important for our topic. And fourth is the actual commission of the crime. So for example, let's say that there was that A intended to murder B. Now if the whole idea or the thought which came into his mind to kill B is the formation of the intention or the mens rea. Now second would come the preparation to commit the offense. So let's say in order to kill B, A arranges certain tools. Let's say he arranges a knife or an axe, or he arranges a gun. So that would be the preparation to commit an offense. Now third is the attempt to commit an offense. Now attempt to commit an offense basically means an act towards the commission of the offense. Okay, so let's say after preparing to kill B, let's say he gets a knife. Now the act of running towards B and the act of stabbing him, that would be the attempt to commit the offense. And if he is successful in stabbing B, and because of that stab, because of the wound which is because of that stab, he dies, B dies, that would be the actual commission of the crime. So under criminal law, formation of intention and preparation to commit crime is not an offense, but the attempt to commit the crime and the actual commission is an offense. So as explained earlier, attempt basically means a direct movement towards the commission of the intended offense. So for example, a person is moving towards a person with a knife with the intention to stab him. This is a direct movement towards the commission of the offense, because if he succeeds in commission of the offense, in the act of stabbing, he would commit an offense. Again, another example would be, let us say that there are a group of persons and they are running towards the house of another person and are armed with lathis or sticks. Now this act of the people are armed with lathis and are running towards the house of another person is basically an example of direct movement to the commission of offense, and here the offense is grievous hurt or commission of assault. Now it is very important to understand is that a full attempt must be made to commit the crime, and only because of certain supervening event the intended result, that which is the crime, could not be accomplished. So supervening events are basically outside events which are beyond the control of the accused. Now consider this example. A decides to kill B, and for this he procures a gun, loads it and points it towards A. So that means the intention has been formed and preparation has been made. Now A pulls the trigger and it hits B, but instead of his chest it hits his shoulder. Now this is the example of full attempt, and this part is an example of supervening event which is beyond the control of the accused. Now what does full attempt mean? See, full attempt means that if an act has been done and that particular act is not thwarted or that is not interfered in any way, it would result in the commission of a crime. So in this case, in this example, if the bullet had hit B, okay, in the chest, he would have died. So that means this is a full attempt. However, a supervening event took place, which is that instead of hitting the chest, it hit his shoulder. Now here in this case, A will be punished for attempt because of one simple reason: attempt has been made, so attempt will be punished. Now this aspect of making attempt punishable under IPC is because of the maxim voluntas reputar pro fact, which says that will is to be taken as deed. That means the will of the person is equal to the deed of the person. Just because of certain extraneous circumstances, the will of the person could not be achieved. Okay, this does not mean the will not be punished, because then otherwise it would lead to a situation that the person would try to commit the offense once again. Now we'll come to the main part of topic, which is attempt to murder. Now, what does section 307 states? Section 307 states that if a person does any act with the intention and knowledge and under such circumstances that if he had caused death by such act, he would be guilty of murder. That means the person had the intention and knowledge, and the circumstances was such that if he was successful in doing that act, he would have committed murder. In that case, the person would be punished with imprisonment of up to 10 years and shall also be liable to fine. Now, this is the first part of section 307. The second part states that if hurt is caused, that means the person does the act and the act is done with the intention and knowledge and under such circumstances that he would cause death, but instead of actually causing death, he causes hurt. In such cases, the person would be liable to either imprisonment for life or for such punishment as in herein before mentioned. So that means he would be liable to fine also. For example, A with the intention to murder Z buys a gun and loads it. Now at this stage he has not committed any offense. A fires the gun at Z. Now he has, if this act is completed to its fullest, he would die. Okay, so that means if the act is successful, if A is successful in his act, he would commit the offense of murder. But instead of killing the person, he simply wounds Z. So he will be liable for punishment provided by the latter part of the first paragraph of this section. And the first paragraph of this, the latter part is basically when hurt is caused. Now we'll discuss the ingredients of section 307. First ingredient is the offender had the intention to commit murder. So that means the intention was similar to that of murder, which is described under section 300 of IPC. Second is death of the person must have been attempted by the offender, and this word attempted is very important. This means that death was not caused, okay, but an attempt was made. That means the intention and the act was such that if the offender was successful in his act, he would have committed murder. If he was successful in killing the person, then he would be charged under section 300, and there is no scope for section 307. 307 only makes attempt to murder an offense. Third is that the act must have been done with the intention of causing murder. This means that the mens rea which is required must be similar to that which is mentioned under section 300 of IPC, which defines murder. Now this particular point 3, was laid down by Supreme Court in Sarju Prasad versus State of Bihar. In this case, and this is very important to note, is that the mere fact that the injury actually inflicted did not completely cut vital organs of the injured is not sufficient to take the case out of scope of section 307. But the prosecution must establish that the intention was one of the three kinds mentioned under section 301 to 303. Okay, now section 300, if you read section 300, point wise, the IPC had described various mens rea or various kinds of intention. Any of those intention is present while an attempt was made to commit the act, then it would fall under section 307. Fourth is the intended result could not be attained due to some outside event beyond the control of the offender. So this is similar to what I told you earlier, which basically means that an attempt was basically made, but because of certain supervening event, the attempted act could not be achieved. Now, what is basically the test where it how will the court will decide that section 307 will be applicable. The test is basically is that the act must be of such a nature that if the last act had remained uninterrupted and successful, death death would be the result. So the last act, if we take the example of shooting, the last act basically would be the firing of the gun, okay, and that remains uninterrupted. An interruption would be caused by supervening events. So let's say if the firer is basically arrested by the police. So this is the test which has to be satisfied. Now we will discuss the case of T. Muniratnam Reddy, and this case would clear all concept with respect to attempt to murder. Just keep these few basic points in mind which I had already explained in the previous part of the video. First of all, there must be an intention to murder. And how are we going to judge whether there was intention to murder or not? We will refer to section 300 of IPC, which defines murder. The mens rea under section 300 should be present in this case also. Second is, a full attempt was made to commit murder. However, because of certain outside events which were beyond the control of the accused, he was not able to achieve what he had intended, which means to commit murder. In that case, the person would be punished under section 307 of IPC. If he, let's say, if he were to be successful, then he would be punished under section 302 of IPC. Then the whole concept of attempt will not come into play only. So, keeping those in mind, in the case of Muniratnam, there were two accused. Okay, one was the son and another one was the father, and they were chasing the deceased because the deceased had insulted the mother of accused 1 and who was the wife of accused number 2. Now, when they were chasing him, accused number 2 was about to release the trigger. That means he was about to fire, but because of hesitation, his hands were shaking and he was unable to do it. During that moment, when this whole hesitation was going on, accused number 1, who was an NCC cadet and who had learned how to fire a gun, he took the gun out of the hands of accused number 2, that means the father, and he fired the gun towards the deceased, and the deceased died because of that gunshot. Here it is very important to note that court held that second accused, with the clear intention to shoot, aimed the gun at the deceased, and he did not release the trigger only because the first accused, noticing the shakiness of his hand, took it out of the hands of accused number 2. So that means the court accepted that the accused number 1 had the clear intention. Now here accused number 1 was chasing the deceased and he even had pointed the gun towards the other person. So this would mean that he had the intention to shoot the other person, but because of his hesitation, which could be because of any reason, he was not able to do it. And the accused number 1 came in and he took the gun and shot the deceased. Here the supervening event is basically the act of accused number 1, that he took the gun out of the hands of accused 2 and he himself shot him. And court held that accused did not commit the offence only because of an extraneous interruption, and this extraneous interruption was the act of accused number 1 taking the gun out of accused number 2's hand. If he had not done this, accused number 2 would have shot the other person and he would have died. That means the attempt would have been completed. So in this case, accused number 2 was charged under section 307 of IPC. Now, when a trial for section 304 is going on, the court would focus on two things. First of all is whether the act was sufficient to commit murder, and second is whether there was intention or knowledge. That means whether there was mens rea which is sufficient for causing murder, whether those mens rea were present or not. If these two things are satisfied, then the final result is immaterial for the court. For example, A was pushed from the fourth floor of the building by B, with whom a property dispute was going on. So a property dispute was going on between A and B, and because of that dispute, B pushed A from the building. However, A did not die the fall. Now, in this case, what will court see? Court would first of all see whether there was an intention to murder A. So yes, because the property dispute was going on, there was intention. Second is whether the act was sufficient to cause death. So yes, under the ordinary circumstances of a case, under the ordinary circumstances, pushing a person from fourth floor would kill a particular person. And if you see the definition of section 300, in that the third clause states that the act of causing death or bodily injury must be sufficient in the ordinary course of nature to cause death. So if the act is sufficient and also there is sufficient mens rea which is similar to that of under section 300, that means of murder, then whether the victim had actually died or not is not considered by the court. The court will only punish the attempt part of it, which is the act which was done and the intention with which the act was done. So that's all under section 307 of IPC. Thank you for watching.